Welcome to Empowering People, episode 4. So today's topic will be on wills and letters of administration. And I'm very honored to have Sukhdev from the Law Chambers of Sukhdev here on this channel to talk to us about wills and letters of administration. So today's episode will be conducted in English. Okay, so let's welcome Sukhdev to Empowering People series. Hi everyone, welcome to episode 4 of Empowering People series, and today I have a very special guest with me, Sukhdev Kaur from the Law Chambers of Sukhdev. Sukhdev, hi, say hi to everyone.
Hello everybody, how are you? Happy New Year.
Sukhdev is a lawyer, okay, she's an advocate and solicitor, and she specializes in the areas of wills and letters of administration, which is what today's topic will be all about, wills and letters of administration. So if you are tuning in today for the first time, okay, or you've been with me for the last 4 episodes, okay, and you find that wills is something that you really want to know more about, you could key in a 1 on the comment below and let us know, okay, how many of you are interested to know more about wills, letter of administration, and how all this works, okay? So Sukhdev, welcome to Empowering People series, okay? I'm really glad to have you here for this interview session. Had your dinner already?
No, not yet.
Yeah,
Maybe after this.
okay, no worry. After this, maybe. Okay, so we're going to talk about wills and letters of administration. Okay, so now a lot of people here in Malaysia, we all heard about wills. We roughly know what wills is all about, but I think in a way a lot of people don't really understand what is a will, how it works, and why do we even need a will? You know, it's like, you know, a lot of people assume that maybe, you know, if something happens to me and I'm no longer around, okay, my house, my properties, my assets, they're just going to go to my children, my spouse, and stuff like that. Okay, so maybe you can start explaining to all of us here exactly more about wills and all this legal stuff, because you know what, a lot of us, everyone's a lawyer. You heard about it? Everyone's a lawyer. But you know, we don't really know our stuff so well, so maybe you can guide us more about all these things.
Okay, sure. All right. So, ladies and gentlemen, I always get this question about will and letters of administration. When a person passes away, okay, the wealth that has been accumulated by this person, you know, that includes houses, cars, jewelry, EPF money, monies in the bank, FDs, you know, how does this go to the children, the wife, okay, the next of kin, the family, the parents? How do they inherit? How are they able to then, you know, utilize this for themselves?
Does it go direct to them, just like that?
Huh?
Does it
Sorry?
directly go to my wife and children?
No, it doesn't. It's not an automatic process, because nobody can step into your shoes to sign the documents, you know, without an order. Okay, if that's the case, then can you imagine how easy it is to transfer properties, monies, and all that? Everybody will be losing stuff.
Because I think that a lot of people probably think, I think it's easy, because, and probably that's why a lot of people don't take the initiative to go and do a will, because you know, I think we assume that it's just gonna go straight just like that.
So you have heard, right? After 7 years, when no one does anything, everything goes into the government funds.
Oh, really?
Right? Yes. So and you know, can you imagine if someone transfers you know, properties, monies, and all that,
Okay,
without your authority? Even when the person is has passed away, okay, you still need that person's authority in order to transfer the property to someone else. Okay, so even the dead can give you authority. How scary is that? How do they give you that authority? It is through the will.
okay.
It is through the order of the court, which is called the probate. If the person doesn't leave a will, then there's the letter of administration. So actually, right, can you imagine, the law even protects the dead person?
Okay. Okay, so do share with us more about wills and all this stuff, you know. You
Okay,
prepared
sure.
some. I was told that you actually prepared some stuff for us to look through, right?
All right. So yes, I did actually prepare some slides, and I would like to share that if it's possible.
Yeah, sure.
Okay, let me share
Go ahead.
screen. Okay, so this is what I've actually prepared for our viewers today. Okay, it's called wills and letters of administration. Now, I'll start with the importance of making a will. You see, the will is the document that actually conveys the wishes of the dead person.
Okay.
Okay, I won't say dead person. It's not very nice. I'll say the deceased person.
Okay.
All right.
Okay.
So now this is the document that actually tells you how the person. He's called the testator. Okay, so when I make a will, I'm called the testator. Okay, how I want my assets to be distributed, who are my beneficiaries. My beneficiary can even be my neighbor's daughter, for all you know. Okay, so it's up to me. I want to give to charitable organizations. I don't want to give to my children. It's up to me. As long as it's stated, that has to be carried out. Okay, what are my priorities? Right. So this is why the will is actually very important. Okay, now in order to give effect to that, we will require information and documents that must be written into the will. Okay, so the contents of the will is very important. This is where you will have the list of assets, all the assets there, the immovable, which is your household, your house properties and all that, movable, your car, your bank, fixed deposits, bank accounts and all, and a list of beneficiaries, all right, who is going to benefit and how you actually want all this to be distributed, right? So who you will need an executor. The executor for a male person, executrix for a female person. Who is this person? Anyone that I, as the testator, trust to execute my will. Okay, my directions that's stated in the will. So this is actually the administrator of the will, all right, to carry out my wishes.
Is this normally a lawyer or someone that they trust? Or can be just anyone?
Anybody, as long as that person is someone that I trust to carry out my wishes and will not sapu my money lah.
Normally, in a lot of movies we see, right, the executor is always the lawyer, right? In a lot of movies
that's movies lah. Now we talk about real life.
I mean, we learn a lot of stuff from movies,
Yes, guidance.
Okay.
No, the executor, the administrator can be anybody.
Anybody, okay.
Anybody above the age of 18.
Okay.
Okay, right. So, for example, if you have a beneficiary who is a minor, you will need to appoint a trustee to jaga the assets that this beneficiary is going to gain until the age of 18. Okay. And then after that can transfer. Okay. So we need 2 witnesses, again, above the age of 18. We need their details because when the application is made to court for the grant of probate, then these witnesses will have to sign an affidavit to say, yes, I witness that the testator signed the will. This is his will or her will. Okay. All right. Now, the witnesses must not be the beneficiary of the will. Very obvious, right? I benefit, I witness. Wow.
You knew it already.
So you can see that this is all, this is the reason why there is check and balance.
Okay.
When someone prepares a will. Okay.
Okay.
So now, having said that, what is the letter of administration? Now, the letter of administration is when is also a document to be applied for instead of the grant of probate. When there's a will, we apply for a grant of probate. When there's no will, we apply for the letter of administration. Basically, an administrator to carry out the distribution. Okay. So what this administrator is for is actually now authorized by either the High Court or the Land Office or the Amanah Raya, okay, to step into the shoes of the deceased person, authorizing the administrator to sign documents so that the property can be transferred. Okay, so remember earlier I said that the law even protects the dead person,
Right.
the deceased person, right?
Yes.
So this is where it comes in. You see, the administrator. So property doesn't get transferred automatically, or nobody can simply sign. They must be authorized. Okay. So when there is no will,
Sorry, I think that's good now, because a lot of us think that this thing is kind of automatic process. Like if I have a children and a spouse, it's just going to automatically go to that. I think a lot of us assume that way. I think previously I had also assumed that way as well. I think I learned a little bit more about wills, but I think that's probably what a lot of general population would think. Okay.
yes,
Yep. And for those who are
yeah.
watching this video right now, if you guys think that's how it works, do let me know. Type a Y, say yes, that's how it works. That's how I thought it was. That it's gonna go straight. Okay. Type a yes in the comments below and let me know. Okay, so Dave, yes, go ahead.
You see, Jackson, what happens is that everybody automatically assumes that they will inherit.
Yes.
So they take it for sure, for rest assured, I'm going to get my father's property, rest assured, I'm going to get my husband's
That big house is
property,
mine.
rest assured. Huh?
That big house is
Sorry?
mine. That big house is mine.
Yes, that diamond, that's in the bank or something is mine. That's what they assume. Okay, but if it's not an automatic thing that they can get hold of, right? Okay, so when there is no will, then it becomes even more dangerous. You know why? Because the distribution of the assets goes through the what we rely on, the Distribution Act.
Okay.
Okay. All right. So when there is no will, the next of kin applies for the letter of administration, becomes the administrator. So that's the first stage. Okay. So once the person has already gotten the letter of administration, then the second stage is to apply for the distribution order. All right. Now, when the person applies for the distribution order, this is where they actually then step into the shoes of the deceased person and be able to sign the necessary documents in order to get the properties transferred. All right. Now, when we are applying for the letter of administration, as it involves two stages. The administrator also has to provide an administration bond and two sureties if the gross value of the estate is above 50,000. So you see one more difficulty here if there is no will.
That means, okay, let me just get this a bit more statement for myself to understand. Which means that let's say I'm no longer around and the value of my estate, which is all my assets, right, is above 50,000 ringgit. My family has to put a bond to make sure that I can apply for this letter. Is that?
No. It's not your family. So it's the administrator.
Okay.
Yeah. So yes, you can say that the administrator is one of your family members, lah. Yep. Okay. Right. Now, why? The question is, why do you need two sureties? That means two persons giving a sort of a guarantee. Okay. The reason is because the person who becomes the administrator, in order to ensure that the assets are distributed, okay, these two sureties must ensure that the administrator doesn't run off with the properties.
Okay.
Then they become liable.
Okay.
Okay, in layman's words lah. All right. So if there is no will, pray that your the value of the assets is less than 50,000. Because can you imagine how difficult it is going to get two sureties? Who's going to stand in there to guarantee? Not easy, eh? Okay, then only can get the distribution order, which is the second stage. You need to make an application. So it involves two stages.
Okay.
All right?
Question. Is it that a lot of people actually get stuck at this stage to actually get that? If they don't have a will, a lot of people get stuck because not everyone can get two sureties to provide a bond, right?
Yeah. So yes, there are situations like that. You know.
Okay.
So, then the process is delayed because you can't even apply it to be an administrator. You
Understand.
see, the sureties and the administration bond is for the first stage, not the second stage.
Okay.
Yeah, so this is one difficulty. Okay, besides the two stages. All right. Now moving on. All right. Here we will see now the pros and cons. Why should you make a will? Firstly, if you make a will today, you can always change it again in 2 years' time, in 3 years' time. Okay, because the situation in your life may change. All right, like you may gain more wealth, or you may have disposed of the old house, or you may have more savings. Maybe you've got unit trust investments. Things like that. So if situation changes, you can change your will. Maybe you have another child, so from 2 become 3. Now you want to think about the third one as well.
What
Okay.
about marriage and divorce?
That's very interesting. Okay, so when if a will was made before the person gets married, okay, and after marriage, not immediately, say maybe in a year or two, let's say there's already one child, you may want to think to revise your will, because now you have your immediate family, which is your wife and your children, to think about, right? Now, upon divorce, uh, then of course you want to revise your will. Otherwise, your divorced wife or divorced husband that was named in the will can still inherit.
The divorce doesn't change the status of the will, right?
No, because it's my wish word, right? It's my wish word. So if for example, a couple divorce, all right, and the husband did not change the will, and he has named the wife to receive that nice, beautiful, big bungalow house, she gets it, lah.
Okay. So
Ah,
just for example, let's say this guy, he's divorced his wife, and then he married another one. So the will is under the ex-wife. So the current wife has no claim over it, right? Unless he changes the will, correct?
yes. So the ex-wife was named as the beneficiary. The will was not revised or revoked. Then the ex-wife still inherits. But you can imagine the new wife is definitely going to fight for it.
Yes. Let's say there's no will. And there's no
Ah.
will. It will go to the current wife, right?
The current wife will apply for the letter of administration to inherit the house. But is the house registered solely under the husband's name, or is it under joint names with the ex-wife? Now, here I must explain something. When a divorce happens, if the house is a matrimonial property, okay, then usually that matrimonial property would have been decided whether they will be selling it off or whether they will transfer to one party or the other. So transfer to the wife or transfer to the husband. So once that is done, okay, which means then the other party is no longer the registered owner.
Okay.
So when that is taken care of in the divorce proceedings, then the new wife or the new husband has no claims over the matrimonial property from the previous marriage.
Okay.
Okay, so which means that hold on. Which means that if there was already a will, the will must be revised.
Okay.
To give effect. Okay, even if the will is not revised, there cannot be a claim. Why? Because there is an order regarding this property.
It comes after the will.
Yes.
But what if the sole owner, let's say it's the husband or the wife, just one person's name, and then he divorces one, gets married, but there's no will. So does it go all to the?
So as long as the house is registered under the husband or the wife as the sole registered owner, then the new partner, okay, the new legally married wife or husband gets to inherit.
Okay.
Okay, right. So, ladies and gentlemen, if you know any one of you all have experienced a divorce lately, and there has been a change in your in your immovable properties, that is your house, condo, apartment, please do revise your will. Okay, because that part of the will where the immovable property is to be inherited by your ex-spouse is no longer effective. It should have been taken care of in the order, the divorce order, okay, the consent order, right? So coming back now, look at the advantages of having a will. The process of applying the grant of probate. Grant of probate is the order from the court that allows the executor to give effect to the will. Okay, so this process of application is not complicated, okay, and it is very cost effective. In fact, it's only there's only one time you go to court to get this. All right, there's no need to apply for a distribution order, because the distribution order is already stated. The will speaks for itself on the distribution of the assets.
Okay.
So it sort of bypassed the distribution order from the Distribution Act. Okay, it is cost effective in terms of distribution to the beneficiaries, because there will be no stamp duty payable by the executor upon transfer of the immobile properties.
Like,
you know, when you transfer,
transfer properties, there's no stamp duty.
Yes. Okay. To be paid by the executor, actually to be paid by the deceased person.
Okay.
Yeah, because you know, when you transfer properties and all that also, you know, that you have to pay stamp duty here and there, right? Yeah, so it takes care of that. Okay. And there is no need for the executor to provide the administration bond and 2 sureties. There's no need.
Okay.
Okay, right. Then when we come to without a will, okay, so without a will, the priorities and the wishes of the deceased person cannot be given effect to. Why? Because anybody can say, oh, this is the wish of the deceased person. He wanted A to inherit. Then another one will say, oh, no, you know, he wanted B to inherit, right? So whose words over who? The fight is endless.
True.
All right. Yeah. So you might as well have a will. Nobody can fight over that. Okay. There's no automatic inheritance, because you know the distribution is subjected to the Distribution Act, right? The administrator of the estate of the deceased person. So basically, the administrator have to go through the 2-stage process. Firstly, the letter of administration, then the application for distribution order. All right. Don't forget, you have to find 2 persons who will agree to stand as sureties.
Okay.
All right. And it is time consuming. Can you imagine going back to the court or the land office 2 times? First, you go and get your administration, the letter of administrator to say that I am the administrator. Then you go back again and apply for the You see, what happens once you have gotten the letter of administration, the properties of the deceased person, let's talk about houses especially, okay, those will have to be now transmitted to the administrator's name. That means it is, in layman's terms, it is registered under the administrator's name.
Okay.
Okay, as an administrator only. It doesn't become his property.
Okay.
Okay. Then when you apply for the distribution order, for example, Jaxen is supposed to get 30%, Lita is supposed to get 30%. Okay. Only then I as the administrator can transfer 30% to you, 30% to Lita, and whoever else that is in the family or Okay, imagine we are all one big Muhibah family.
Okay.
All right.
Okay.
Yeah. So you see, that is why it's time consuming, because you have to go back and forth twice.
Mm.
And you know that now with the MCO, with the land office closed temporarily, you know, and they are open intermittently, it's just going to drag. Yeah, it's just going to take a long time.
So,
Okay, and we have seen on Facebook where, you know, a lot of people have actually expressed their experience. Okay, that, you know, it just takes 2 to 3 years and it's expensive. All right, but if you have a will, you go to court through lawyers, and you get your grant of probate. Then, you know, although the property will have to first be transmitted into the executor's name and then transferred to the beneficiaries, but we don't have to go back again to get a distribution order. So if, you know, without a will it takes 3 years, now it's just cut down to, say, a year and a half maybe. You know, you save a lot of time. And paying the fees twice because you have to apply twice, that's not cheap. You go to court, it's only once. Okay?
okay.
Yeah. You go to court for a grant of probate. If you go to court for a letter of administration, yes, you have to go back twice. First for letter
Then for
of
distribution.
administration, then the distribution order. Okay? So you'd still have to go through that two process, even if you're applying for the letter of administration from the court. All right?
Looks like a lot of
So come to us and we will help you.
Okay, so for those who are watching,
Okay.
right, if you have not yet done your wills, type in a 2 in the comment below if you've not done your wills, okay? Because why? I think you should all start thinking about doing some wills up already, okay? I think looking at the kind of process that Sukhdev is talking to us about, does it look like something that I want my family to go through? You know, it looks like a very long, tedious process just to inherit whatever I've left for them. Okay, doing the will is so much easier. So if you have not yet done your wills, just get up and go and do your wills. Okay, so Sukhdev, yes, please continue.
Okay, so now there are certain what you call that, assets, okay, that cannot be named into the will. For example, organizations such as KWSP, EPF, insurance companies, where they have a nomination form. Okay, maybe you know, if some of your unit trusts, they ask you to nominate your beneficiaries. All right. So as long as a nomination forms is completed and filed with the respective organizations, then this cannot be stated in the will to say that, oh, although I have nominated A to be the beneficiary, now I'm changing my mind to have B be the beneficiary.
Okay.
Changes must go to that organization.
Nomination.
You go and update your nominees. Okay. Now, but if, for example, someone has not nominated anybody at all to receive the proceeds, right? Then we can always, when we are applying for the grant of probate, assuming there's a will, we can always include it in there, and it will be then distributed according to the Distribution Act. Okay. And if the deceased person did not nominate, yes, as the case may be, then it can be included, these proceeds, into the list of assets. Okay. But you see, even if you have nominated someone, you can always, you know, state in your will that, oh yes, I do have EPF account, I do have a CPF account in Singapore, I have nominated. So go and look at the nomination form to see who is nominated.
Otherwise,
right?
because no one goes and claims.
Yeah. Okay. And yes, there is no automatic inheritance, so it goes through the Distribution Act. Okay. Besides that, you can even, you know, one can even state in the will how the how you wish, you know, certain things to be done in the family For example, like, okay, after my death, I want both my daughters to live happily together. Um, or you can say that, I want my daughters to take care of their grandparents, things like that.
Last words.
Last words. You can always include. I mean, all that, no, there's no legal effect to that, but I'm still telling you my wishes. But I
True.
wish you all to remain happy,
True.
take care of your health. Put a little last letter, last love words for them.
Okay.
Okay, right. So I have also done several videos, which is available at my Facebook page. Right, there's a YouTube playlist here, which these videos were actually a part of my initiative to answer questions from the audience. Okay, and they are very helpful because they are real life questions. Each question is very different. You remember I did one with you too, Jackson, right? Where you taught us about the trust, right? Which is actually very, very helpful. So I hope that the audience can benefit and that, they are able to make the right choice to
Okay.
actually make a will. Yes.
So for those of you who are watching now, if you want to know more information, you can go to Facebook, look for Law Chambers of Sukhdev. Okay, that's her personal page where you can actually find out more information about wills and letters of administration. And if you have any questions that you want to ask us as well, even right now or even after the talk is over, do comment on the comment below, and we will try our best to provide you with the answers that we hope that may be able to help you answer whatever that you have in mind. Okay. So, first of all, I would really like to thank you for taking your time out to talk to us about wills and letters of administration. Like I said, I'm sure this is an area I know, or I personally myself feel that it's important for a lot of us to understand, to know more of, because a lot of times we take legal stuff for granted. We always assume it's going to be like this, like this, like this. Personally, for me, I find that this is very, very informational, and I kind of enjoyed it because it really tells me a lot about how I should proceed with my own inheritance, what I should do, shouldn't do, because I know I don't want my family to go through all the hassle of going through the court, getting this letter, doing this. If something happens to me, just for them to get my properties. So yeah, I think this is very, very good information. Okay. So before we end today's session, do you have anything you want to say to everyone about wills and everything like that? Or better yet, when will be a good time to do wills? Should I wait until like I'm 60 to do wills, or what if I'm 20, I'm 30 years old? I'm still young, like I know I can live forever, that kind of, when will be a good time to start doing a will?
Okay. My last words before we part today. Jackson, thank you so much for inviting me. Ladies and gentlemen, I hope that, the presentation, the slides that I've provided for today will be beneficial to you all. You can always refer to it, it's basically your free consultation slides. Okay. Now, answering the question, the most important question, when is the right time to make a will? There's never a right time. You just have to sit down and prepare your list of assets and your list of beneficiaries, and then go to either lawyers. You can come to me, you can go to Jaxen, someone who is professionally trained to write wills, so that all the technicalities can be taken care of. There is, like I said, there is no right time to write a will. You just have to sit down and do it. It doesn't matter whether you're 30 years old, you're 40 years old, you're 60 years old. Okay, as long as you have a sane mind, you're still in the right frame of your mind. Okay, you need to sit down and write that will, give your instructions. Okay, now why the sane mind? Because imagine if you're writing your will when you're 75. Okay, and anybody can challenge that will. Anybody who's not satisfied with that will can challenge that will. Even if you are at age 45 and you have problems with your mental health. Okay,
Stuck at home too long from MCO and then you go crazy.
anything, yeah, anything that affects your mental health, it affects your sanity at any age, that will, okay, can be subjected to challenge. Why? Because you're not in the sane mind to have written that will and given the instructions.
Okay.
Anybody can challenge that. Okay, so that is why the two witnesses are very important. Okay, the witnesses are not just signing for the sake of signing and putting their name and address there, that, oh, I have witnessed this. But you see, they are actually saying, when we prepare the affidavits for them to be filed together with the application for the grant of probate, the affidavit is going to say that, yes, I witnessed that this person was in a sane mind when he prepared the will or she prepared the will. Okay, so that is why the witnesses are required. They are not required there for fun. Okay, there's a reason there. So there is a technicality there. Okay, and so you want to prepare the will when you are sane, when you are healthy, so that you know your decisions cannot be challenged, will not be challenged. All right, and it gives you a sense of satisfaction too. I know that, okay, whatever I have today, and if I'm gone today, my children, my family will be taken care of. Say you're 30 and by the age of 40, you're still living healthy and fine. You have accumulated more health. There's a certain change in, your wealth. Make a new will.
Okay.
Make a new will. Change it. Maybe you have added 2 more family members. Maybe you've got 2 more children. So your old will only catered for your earlier 1 child or earlier 2 child. So what about the 2 new ones? Include them. Change your will.
Okay.
Yeah. Okay. So I hope that all this has been, guidance for you, that you are able to look at making a will in a more practical manner. Do it. The COVID is next to us. MCO 2.0, the COVID is next to us. We do not know when it's our time. I pray that no one gets hit with COVID, but the reality is it's next to us. Okay, so stay safe, make that will. Your loved ones will be very, very grateful that they don't have to go through the hustle and the bustle and to wait for such a long time. It's crazy. Okay, so stay safe and social distance. Thank you, Jaxen.
During this MCO time, I think this is the best time. Okay, look, for all of you guys out there, if you are stuck at home for MCO, do take this time to really think about all the assets that you have, list them down, because you may want to think about writing a will to protect them. Like what Sukhdev said, it doesn't matter if you're 20, you're 30, or you're 60 right now. There's no good time. The best time was yesterday. Okay, because it's better to be 5 years early than 1 day late. Okay,
exactly. Yes.
So today, again, thank you very much for coming for today's series on wills and letters of administration. On behalf of everyone who's watching today, we'd like to thank you for sharing your knowledge and your experience in this matter with us, and to help guide us to understand better about how wills work and why we should have a will. Thank you very much.
Welcome.